Well, good afternoon and welcome to Leadership Lounge with Todd. I'm Todd Sears, the founder and CEO of Out Leadership, and I'm incredibly excited to be joined today by three phenomenal rock star women who are going to lead us through an amazing conversation around the Supreme Court cases, as well as a lot of the amazing work that Lambda Legal is doing around the country. Before we dive in, as always, I want to say a few thank yous. As you know, Out Leadership has 82 member firms around the world that have been supporting our work even through this crisis. And I'm very proud that they continue to, both as members and as sponsors. I want to especially thank our global sponsors, HSBC, KPMG, EY, Ropes & Gray, RBC, and Greenberg Traurig. And as always, I want to give a few shout outs to some member firms this week. We'd like to thank Bloomberg, BakerHosteler, Clifford Chance, Dow Chemical, Equitable, Goldman Sachs, Moody's, Mizuho, Morrison Forrester, Paul Weiss, PwC, Thomson Reuters, Capital One, Citigroup, and Simpson Thacher Bartlett. Just a few of those firms, a few of our larger firms, and we just want to thank them for all of the work that they do on our behalf and the support that they give us that allow programs like this to happen. So as a quick background to today's conversation, I want to give you a little history on Lambda Legal and my involvement. The organization is the oldest LGBT civil rights legal organization in the country and has won hundreds and hundreds of impact litigation cases around the country in its history. And why that's important is if you think of, and I will use my personal perspective on this, is that every advance that we as a community have had in the last 45 years has directly and indirectly come from an impact litigation case that Lambda Legal has won. Whether it's marriage equality, or overturning sodomy laws, or non-discrimination for trans people or HIV, Lambda has been at the front lines of this fight for longer than I've been alive, which is saying something. I've been involved with the organization since 1999. I went to my first Lambda event and was blown away, and ever since they have been on my very, very short list. I'm on the board, and I've only been on the board of 3 LGBT organizations in my career, and Lambda is one of them. I've been proud to raise as much money as I can for the organization because I not only believe in the mission, but I look at the impact of what the dollars we raise actually do. And I would argue that they are in the top 1% rarefied air of organizations that do the most with what we are able to raise for them. They have over 80 cases on the docket right now. Some of them have been long-term cases, including suing the Trump administration for the trans military ban, all the way through to a case I know we'll start with this morning that they've just gotten a great positive judgment in South Carolina. All of the cases continue, and specifically today, we are going to talk about the Supreme Court, Lambda's role in that case, as well as the perspectives of what are going to come out of that case. And so I'll give a quick intro to the amazing leaders that we have with us this morning to discuss it. I'm going to start with Katrina Quicker. Katrina is a partner at BakerHosteler in the patent area, and she joins me on the board of Lambda as well, and is a straight ally. Katrina also, I just found out, so there's this, I always like fun facts for folks, and Katrina apparently won second place as best waitress in Bloomington, and she can walk us through exactly the machinations and the campaigning that was involved for her to win such an austere and auspicious award. She's also been deemed a pharmaceutical virtuoso by the IAM Patent 1000. But most importantly, she has been a leader in the diversity and inclusion space for BakerHosteler. Baker, as you would be well aware, has been very active in a number of LGBT cases, not just with Lambda, but with HRC and a number of other organizations in our community, has donated thousands and thousands of pro bono hours towards our causes. And I'm thrilled that she's here. So next we have Sharon Mcgowan. Sharon is the Chief Strategy Officer, Legal Director for Lambda Legal. Sharon actually came from the Obama administration, has been a leader in the legal space. She was Principal Deputy Chief of the Appellate Section of the Civil Rights Division for the Department of Justice, which is not just an amazing title, but the amazing background. And actually, Sharon helped Lambda Legal open the DC office for the organization and has been leading it ever since. Has done a tremendous job, and I think you'll see has huge energy. And as I've said to her many times, number one, the amount of work that these lawyers do on our behalf is stunning, and I'm always amazed that they're able to pull it off. But in addition, Sharon has a great ability, as does Jenny, to explain very complex legal structure to idiots like me. So I'm excited that she's able to be here, and I want to thank her for all the work. And last but not least, Jenny Pizer. Jenny is the Lambda Legal Law and Policy Director, and I've had the pleasure of knowing Jenny for, oh my gosh, a very, very long time, probably 15 or 20 years. And Jenny has not only worked for Lambda, but she's also done work for the Women's Institute, which is one of the other organizations that I've been on the pleasure of serving on the board for the last 13 years. And if you look at the intersection of both of those pieces of work with Jenny's incredible brain, the strategy that she's able to bring, and not just the research pieces of it, but also how they're able to construct the cases is massively important. And I've always been so impressed with the strategy that goes behind how Lambda chooses the cases and how they plan which case goes in which district, and which all of the different pieces that are controllable where we can, Lambda thinks through in a very, very strategic way. And that's been the reason that it's been so successful as an organization. So I'm really excited to have the three of you here. And what we've tried to structure are sort of a few things. So I'm going to ask Katrina to kind of kick it off and give it a little bit of a background in terms of the work that Baker has done and her sort of perspective as a convener of some of the other law firms. As you know, Out Leadership helped convene a business statement and an amicus brief with HRC, Out and Equal, and others this last fall. And Katrina and another number of other firms have been involved with amicus briefs from the legal side of the world around the Supreme Court cases. I'm going to ask Sharon to kind of give us more of an overview of the case and the different pieces, and then I'm going to ask Jenny to kind of walk us through the outcomes and the various outcomes that they see happening, and what would sort of the impact of each of those outcomes be. And then I've asked all of them to kind of think through how some of the structures that we're seeing in these cases are actually going to impact other cases that impact our community, right? The religious freedom laws, for example, and the religious freedom arguments that have been made in this case are not unique and are being used strategically in lots of different cases all across the United States. So I really want to get a sense from them about the broader impact of how some of those who are against us are continuing their fight. And as Kevin Jennings, the CEO of Lambda, has said a number of times, the fight is like the Terminator. They just keep coming. So with that, let's open it up with Katrina. Katrina, thank you again for joining us, for supporting both Out Leadership and Lambda. Give us a little bit of perspective from the law firm side, what you've been working on, and I'd love you to actually comment on why this matters to you as a straight ally, because allies are key in our fight.
Sure, I'm happy to, and thank you for having me. BakerHosteler is one of only 32 law firms that is a national sponsor of Lambda Legal, and we have been for a number of years. And as part of that national sponsor support, we are given opportunities to work alongside some of the Lambda Legal lawyers, as well as collaborate with them on cases and do research for them when specific areas of law that they need some additional support are requested. So that has been an enormous opportunity for not just myself, but we have over 1,000 lawyers, and they all want to, raise their hand and help support the cause. The firm and the other 32 law firms that support Lambda Legal, they see this as an opportunity to improve and enhance their overall culture, which is very important to me as a straight ally. The way that I found myself into the civil rights and LGBT cause is that I live in Marietta, Georgia, and the area that I live in had a ban on Boy Scouts at one of the local schools. There was another school down the street from me who required that the parents sign a contract that says that they will not support any LGBT causes, and that their kids that are going to attend this private school will not participate in any kind of LGBT culture. And wow. There ended up being, because I'm straight and I'm a mother of 4 and I'm married, I had unfortunate occasions to listen to people say some pretty nasty things that they assumed that would be okay with me. And it just, it was shocking that it was, only 5 years ago. I joined the board 5 years ago, and it just made me insanely upset, and I didn't want to raise my kids that way. I didn't want my kids to have that attitude. And I leapt into as much action as I could. And I just find some of the most brilliant creative minds and people that I have come to know in the LGBT community are such an inspiration, and they have made huge strides given how much pushback they've received, at least in the South. And I wanted to make sure that I wanted people to know that this was not acceptable. And I worked at Baker with people that also felt very passionate to make sure that we would financially support Lambda Legal and that we would help them in all the cases as they needed. So, and we're not the only law firm. There's multiple law firms that have been involved, and they are necessary to keep this organization going.
Wow, thank you, Katrina. I first of all, I'm still stuck on the fact that they can't participate in LGBT culture, which basically means they can't do anything. They have to sit in a black box by themselves, right?
That's right. And I think they had a Rolling Stone article about this one school down the street, and this is down the street from where I live, and I'm in a suburb in Atlanta. So, I mean, this is still happening and happening often. And at least in the South, so much of it is steeped in this is because it's against our religion.
Which, you mentioned the Boy Scouts. That was one of Lambda Legal's cases early on, was James Dale versus the Boy Scouts, which I think just hit the 25th anniversary, which is kind of crazy. And James Dale is a good friend, and that's been an amazing thing to watch him as a leader. But the fact that it is still happening in the South, and my parents live an hour from you, actually, Katrina. So, I grew up in North Carolina, so I'm very well familiar with the religious freedom. This is against our culture. I don't care, but I don't want to say all of those things. And I think that's actually so. One, thank you for being a straight ally. Thank you for using your passion, one, to raise your kids in an inclusive way, and to getting your firm and others to lead the way to support Lambda and this important work. And
70% of Lambda's cases are in the South.
Right, the entire Southern project that Lambda's been working on. That's exactly, and which is just mind blowing, right? But that's actually why I'm excited about the impact litigation that they're doing, right? This case that I'll ask Sharon to kind of start with in South Carolina has the opportunity to ricochet across the South, and Lambda chooses cases that have the opportunity to have massive knock-on effects, not just win a case. So Sharon, let's start with that. We've got some good news this morning. Let's start with the good news, and then let's do a little overview of SCOTUS.
Absolutely. Well, first of all, Katrina, you're going to make me all well up right 5 minutes into the program. We love you so much, and Todd, we love you so much, and to anyone who is on this call who has supported Lambda over the years and supports us now in this moment where our work is as vital as ever. Just thank you from the bottom of my heart, from Jenny's heart. I've been greetings from the entire organization. We are very happy to have good news to report. Just this morning, I was scrolling on my phone with a child hanging off my leg, trying to get the latest news out of South Carolina, where we overcame a motion to dismiss in one of our cases that really is indicative of a whole area of work that we're doing right now in this area around religious exemptions. We represent a same-sex couple in South Carolina who wanted to apply to be a foster parent, but the largest service provider, child welfare service provider in South Carolina, an organization called Miracle Hill, wanted to be able to turn away any prospective parents who did not, kind of similar to what Katrina was saying, sign off on their particular set of worldviews and religious beliefs, and specifically those who they would only accept those who adopted an evangelical Christian perspective, and obviously that also meant excluding same-sex couples and anyone who believed that same-sex couples were entitled to equal dignity under the law. Now, the interesting thing is that in this case, there are actually regulations from the Department of Health and Human Services from the Obama era that ensured that anybody that was receiving federal support for their child welfare services had to comply with non-discrimination requirements that would have prevented this kind of discrimination. But obviously we know everything good and right that the Obama administration has done, particularly in the realm of civil rights, but LGBT rights in particular, has been in the crosshairs under this administration. And so Miracle Hill originally was told by the state of South Carolina, we can't recertify you because you're not complying and not agreeing to comply with these non-discrimination requirements. And so what Miracle Hill said was, well, we want an exception. And Governor McMaster in South Carolina, having recently left the Trump administration, said that he was going to pursue that and went and petitioned to HHS and basically got a blank check for them to continue to operate receiving state and federal funds, even though they were blatantly going to be turning away people based on their inability to comply with Miracle Hill's very narrow religious beliefs. And so last May, we filed a lawsuit claiming that that kind of conduct not only violated the Equal Protection Clause, but also violated the Establishment Clause, where you have the government basically deciding that they are going to allow someone to use a religious litmus test to perform this really essential service. And fortunately, we got a great decision from a district court judge in South Carolina today, agreeing that we are able to move forward with our claims. Obviously, a motion to dismiss is only an initial stage of the case, so we have a lot more litigation to do. But this is a really important sort of landmark and milestone in an ongoing set of cases that we are seeing where religious entities are not only sort of demanding the right to discriminate, but they're demanding the right to get government dollars to subsidize their discriminatory practices. And we may get to this as well. This issue is actually headed to the Supreme Court in the fall in a case that's coming out of Philadelphia, where a Catholic service organization basically sued the city of Philadelphia when Philadelphia said, look, if you want to have your own rules, you're not going to get city dollars and kids through a government pipeline to place with families. And, so that is, those issues are continuing to be front and center, but Lambda Legal has always been at the front line of that work. And today's decision is one of many cases on our docket where we are there fighting not only for the really important constitutional principles that are at stake, but one of the things I want to just make sure everybody knows is that these cases are about people. And in this case in particular, this is about kids. Because every time you turn away a potential parent, what you are turning away is the chance of having a safe, secure, and loving home for a kid who might otherwise be forced to stay in a system that's not capable of providing that love and care to them. And it's not because these parents aren't capable of providing that love and care. It's because someone has decided, in a gatekeeping role like Miracle Hill plays in this case, that we don't like who you are or how you live your life. And even though you could provide a perfectly wonderful home for these kids, the state is now letting us shut the door in your face. And Lambda Legal is here with our crowbar to pry that door back open.
And Sharon, if I could add on there, when there's this kind of litmus test is being used to select parents, it means that that particular way of looking at the world is creating the environment in which kids are being raised. So what about those young people who are placed with parents, but they're placed in an environment that for some kids is going to ensure that they get messages that there's something wrong with them, or that there's something wrong with their classmates or other people that they interact with in their lives. So it is about the state then endorsing a set of messages that can be really harmful to the kids and to everyone they interact with moving forward.
Well, and it's factually incorrect, right? I mean, there is research from the Williams Institute that has done, there's a longitudinal study of the past 35 years following lesbian parents and the outcomes of their children, showing that children of gay and lesbian couples fare actually better than statistically average because we don't really tend to have accidental pregnancies. So
we don't have to rub it in, we're happy saying that we're just as good, but but you're correct about what the studies have indicated.
Yeah. And so, I mean, that's what just blows my mind. So that's why I love, all of these different strategic arguments when we can actually put facts into these cases and take it, it's not about religious freedom. It's actually about what's best for children. But I think 13 states so far, at least, have rolled back these regulations and allowed adoption agencies to discriminate against gay and lesbian couples. I think that's right. Is it 13? I think that's what I've got in my head.
It's always a little hard to say. I was going to say, Jenny and I would sort of say, there are the states that have been brazen enough to do it in an explicit way, and then there are also the places that are doing it as a practical matter. And so fortunately, we have more states now that are affirmatively out there promoting non-discrimination, and I think that is really the gold standard. We want there to be that clear and explicit commitment that the welfare of kids will be what drives these policies. And to make sure that is the message that not only the kids are receiving for the reasons that Jenny identified, but also to make sure that anybody who is potentially thinking about this doesn't hold back and keep their cards close to the chest because they're afraid of being turned away.
Right.
And I just want to go to Katrina's point. This is one of those cases, again, where we've been able to do this incredible case with the partnership of another one of our law firm sponsors, Cravath, in New York. And again, it's just another example of how there are amazing lawyers at Lambda, but part of how we are able to do as much great work as we do is through leveraging these kinds of pro bono partnerships. So if there's anyone from Cravath on the phone, I want to give a little hat tip to you, but also just use that as another example of how this partnership with our supporters in the law firm community has really been invaluable for us.
And I guess what I would add to that is, and Todd, you flagged it before we get to the Supreme Court example of these things, is the tension between having good rules in place that tell the agencies how they need to behave, and those who push back using religion arguments or free speech arguments. Our Youth in Out-of-Home Care project works on exactly this. They are very involved in this case that had this wonderful result today. They also work in states, and some of these are the friendlier states or the states that are newly friendly, where we have wonderful child welfare professionals staffing the system that are very receptive to the conversations with us about what their regulations should look like, and getting those non-discrimination sort of open to everyone, what good parenting looks like, what kids need, to have the rules reflect that rather than views that stigmatize some people. And we've had some wonderful success when you ask which states have good rules, well, it does depend what we count, but that number is going up in part because of this work with these wonderful state-based work groups of child welfare professionals together with our legal expertise to get good laws on the books. And sometimes that's about telling people who mean well what doing well looks like, because sometimes they just don't know. And that's an important part of the sort of, here's the vision of how society should work. In case you didn't know, here's what it looks like. And we're happy to work with you to make that happen.
Right. Well, and that's the proactive game, which is just as important as the defensive game. Right. Well, so let's dive into the Supreme Court here. So Sharon, give us the top line. I think everyone on the call is familiar with the three cases, but still probably worth just giving the 30-second on the cases. And then let's kind of go through how the arguments ran, and let's think through some of the scenarios. And then if you, Jenny and Katrina, want to reflect on the different outcomes. And we've got some questions on the side that we'll kind of work in, specifically around how if SCOTUS rules a certain way. One of the questions was, if Amy Stevens passes before the court, hands down the decision, what impact will that have? And then there's another one around Department of Children and Family Services that we can get to after that. So Sharon, over to you.
Yeah, thank you. No, and just before we move to the Supreme Court cases, I did want to sort of acknowledge the fact that there is, in fact, a large coalition working on this, focused on getting a federal law called Every Child Deserves a Family, that our own Curry Cook, who's the director of our Youth and Out-of-Home Care, is one of the co-chairs of that coalition, along with Family Equality Council that many of you on this call may know. So yes, there's a lot of work that is going on in this area, and we're very proud to be doing some of these cases sort of on our own, but also doing it in larger coalitions. So thank you for acknowledging that in the comments. With respect to the Title VII cases, yes, some of you may have recently seen the news over the last 24 hours that unfortunately one of the lead plaintiffs in one of the cases, Amy Stevens, has been declining in her health for quite some time and has recently entered hospice care. And so for those of you who, in whatever way you can hold her and her wife close to your heart, I would hope that you would do so. I think that in terms of sort of how that case would play out, it would be probably premature for me to sort of speculate. You know, the ACLU is representing Amy, and this is one of those interesting cases where the EEOC had actually originally been pursuing the case on Amy's behalf. And so what would happen procedurally in the event that she passed, I don't think the case would go away completely, but obviously just as a real world impact, you know, the devastating thought that Amy would have spent her last days fighting to not only defend her own dignity, but to ensure that discrimination like this did not happen to other people is really, it's heartbreaking, and it feels particularly cruel at a time where the world is feeling particularly cruel right now. So I think it's important to acknowledge that. And frankly, I mean, there were windows of time where we thought Edie Windsor might not live to see the win in her case.
Right.
Another example of the fact that every one of these cases that we bring involves people. And I want to just salute those who are willing to serve as plaintiffs in these cases, because without the plaintiffs, we wouldn't often have cases that we're able to bring. But the three cases that are now pending before the Supreme Court, but all put together, sort of raise the question of whether or not the federal employment discrimination law under Title VII allows there to be claims for sexual orientation and gender identity discrimination as part of its prohibition on sex discrimination. I'm smiling and looking at Katrina. Georgia has been an endless supply of these cases over the years. Lambda actually had one of these sexual orientation cases that we had hoped to bring to the Supreme Court a few years ago when Justice Kennedy was still on the court. But, you know, as the song goes, you can't always get what you want. But those who remember Jamaica Evans' case, that was one where we were rejected on a motion to dismiss at the 11th Circuit. But now we actually have another case that came out of the 11th Circuit on behalf of a social worker in Cobb County, named Gerald Bostock, who was fired arguably or allegedly after his employer learned that he was gay. That case went up on a motion to dismiss. We also had a case that was actually a wonderful recognition of the fact that the law should cover these claims that came out of the Second Circuit. This is a case involving an individual who worked as a skydiver with a company called Altitude Express. And the case is interesting in part because at first he lost, and the case is actually continuing to be brought forward by his successors because Don Zarda actually passed away, but his surviving spouse and sister are keeping the claim moving forward. That was a case where they ran into prior precedent from the Second Circuit saying that these claims could be brought forward. But in part, with the assistance of Lambda Legal, we were there arguing as amicus in that case. We convinced the Second Circuit to reconsider and go en banc, which is when the entire court comes together and says, wait a minute, we've got this old decision on the books. We really need to look at it again. And realized that all of the analysis that they had used to throw these claims out really could not be reconciled, not only with the words of the statute, but also with the prior Supreme Court precedent that, as written by Justice Scalia, as we all know, sort of that hothead hippie, said you have to look at what the law says, and even if you think that maybe Congress didn't have that particular form of discrimination in mind, if the law reaches it, the law reaches it. And of course, in that case, this was back in the late 90s, the question that Justice Scalia was facing was this issue of same-sex sexual harassment. But the same analysis applies here, where you're talking about claims of discrimination, where if Don Zarda is fired because he has a male partner, but Donna Zarda would be fine having a male partner. The only thing that's different between Don and Donna is their sex. It may be that there are other things also in the mind of the employer, but when the claim fits, the law should reach it. And so those two cases actually went up to the Supreme Court together, one having the employee win and one having the employee lose. And then this third case on behalf of Amy Stevens was a case that actually was litigated fairly extensively with the EEOC against a funeral home in Michigan, where Amy came out to her employer after many years of exemplary service. And not surprisingly, unfortunately, in many of these cases, you had the employer basically say, you now are no longer a good fit for our organization. And so that case went up to the Supreme Court as well. I think the gender identity case was a little bit more of a surprise that it was granted, because the law has been so solid in terms of finding that claims of discrimination by transgender people would clearly fit within sex discrimination law. Mm-hmm. But unfortunately, as we've seen from the bad guys on the other side, including the Alliance Defending Freedom, and now unfortunately the Trump Justice Department, which underwent a 180-degree reversal on this, the kinds of arguments that they are making would really try to sweep out coverage for both sexual orientation and gender identity claims. So the case was argued back in October. I think a lot of us left feeling like there was a path to 5 votes, and some of that has to do with the fact that the argument is really a very lowercase c conservative argument, right? It's don't worry about congressional intent, don't worry about legislative history, all of the things that the conservatives tie themselves up in knots about hating. This is a look at the words of the statute and it applies. And I had to laugh because in those first moments of the argument, Pam Carlin was up arguing the sexual orientation cases, and she went through her opening spiel for about 3 or 4 minutes, and then the bench kind of went silent, which was kind of a sign that this actually really isn't a very hard case at all. And then the chief, realized that it would probably be good form for them to, hit her with a few more questions. But we left basically, with an understanding that, look, the conservatives may very well decide that they want to achieve a different outcome here, and they want to find a way to read LGBT people out of this law, but they would really have to jettison a lot of their very strongly professed conservative statutory interpretation principles to do so.
Right.
And so now we are kind of in that window of time where we are refreshing our button, when the court announces decision day, because we're doing it all remotely at this point. But we may see a decision in the next few weeks because it was argued so early in the term, but we could also sort of see this be one of the late June decisions that we are used to seeing when it comes to LGBT jurisprudence.
So 2 quick follow-up questions, and I'd love to get Jenny's perspective on all of this as well. In the arguments and some of the questions that were asked from the bench, anything sort of jump out as, wow, that was surprisingly positive, or, oh gosh, that's going to lead us in a negative way? And then 2, there was a question on the chat around gender being immutable and how that ties in from a biological perspective versus an identity perspective. And how did that sort of play out in the arguments?
So I think a couple of things that came out in the argument that I think certainly were signs for hope was when you had Justice Gorsuch saying things like, well, let's assume that sex was at least part of what was going on here, right? And just even that concession alone is enough to kind of get you over the finish line. But then he would say things like, well, should we take into account, that, the fact that our interpretation of this law that's been on the books for a long time might lead to massive social upheaval, which, of course, first of all, is just factually wrong, right? Because transgender people are working and using restrooms throughout the country, every day without causing massive social upheaval. But that certainly is not, the general jurisprudential technique that you would see from these strict textualists. So I think that those kinds of questions, that are obviously sort of supplemented by questions by some of our more supportive members of the bench, like Justice Kagan, really made clear, how straightforward the path is to the right answer. But again, we know that this is a court that has found ways to tie itself into knots to either avoid reaching the right answer or kicking the can down the road. So we'll see what happens there. But the other thing, in terms of this question about whether or not gender is immutable, I do think that there was some discussion during the argument in the Stevens case that did reflect the fact that this was one of the first times that these members of the court have grappled with questions of transgender people and transgender identity, and there was some confusion about how they were using pronouns. This case didn't actually necessarily require the court to reach the question of whether or not an individual's gender identity itself should be understood as part of one's sex. And in fact, in many of our cases, we have scientific experts where they're talking about how your gender identity, the sex in your brain is as biological as your chromosomes or your other body parts. So there's a whole area where that issue is sort of being litigated as a factual and medical matter. And we actually have the better of the argument and have been winning it quite significantly, even though it sort of runs into, I think, some long-standing beliefs that, the Irish in me, don't bother me with the facts, I know what I think. So we're going to come at people with the facts. But in this case, part of what the argument was, making it a lowercase c, really conservative argument, is you don't even need to sort of get into that question, because at the end of the day, the employer had gender-based perceptions of who Amy Stevens was. And when she fit into a certain box, they were willing to have her as an employee. And once she left that box in the employer's mind, then they didn't want her anymore. And that's enough. That is all you need. So there are other questions that will probably be litigated down the road. But for this case, it was very carefully sort of constructed in a way that didn't ask the court to bite off more than it needed to reach the right outcome in this case.
So Go ahead, Jenny. Yeah.
Yeah, well, so one thing I would add is that there are a couple of different parts of these sex discrimination theories that are in these cases. And so, one possible outcome would be that the court could say, under the sex stereotyping line of cases that has been our law on the books for decades now, she wins because she didn't present as a woman according to the stereotypes that her boss had of how women should look and behave, or how men should look and behave in a workplace. And so the court could rule in her favor and in favor of the position that the EEOC did have until recently, and say we don't have to decide this other question, which we think also is quite straightforward in a logical reasoning way, but they could say we don't need to decide whether discrimination based on transgender status per se is against the law. She can win on this other ground, and we'll leave that question to another day. It would certainly be radical and inconsistent with anybody's understanding of small c conservative to toss out the window decades of sex stereotyping law. And that is the law on which we and other lawyers have been winning cases for many years now on behalf of trans and gender nonconforming workers, and also sometimes on behalf of lesbian, gay, and bisexual workers who are seen in various ways to not conform to other people's sex stereotypes. The other thing I would add is, as we think about what this court might do, is looking at the bigger landscape. And Todd, I think this may have been where you were about to go with this, that as Sharon said, we have these very important discrimination cases. What does the current federal employment non-discrimination law cover, and what does it not cover? And then there are religion cases. What does religious freedom actually mean? What does our law protect, whether it's the Constitution or whether it's a federal statute or other sources of protection for religion? And so these two things are percolating at the same time, because if there is coverage by the statute, that might not give us the ultimate answer if an employer or a school or a hospital or somebody offering services has a religious right to disregard the law. In other words, the law might cover, except not. And there are multiple cases that the court is hearing now about religion and the scope of religious rights to disregard non-discrimination laws. And so these things are at play at the same time. And we know that this court, this was true for Justice Kennedy before he retired, but it's true for some members of the current court, that they feel they have very strong views about how broad religious freedom ought to be in some contexts. And the answers to those questions are going to be very important ultimately to who has protection and who doesn't.
So I want to think through a couple of things, and there are a couple of questions that I want to sort of embed in this that have come across the side here. Actually, one of them was around an equality index for the states. And I would be remiss if I didn't mention Out Leadership Climate Index that we built and launched last year. We ranked all 50 US states across 20 publicly identifiable data points, including the data points we're talking about today, non-discrimination, but also around gender identity, ability to change birth certificates, driver's licenses, HIV criminalization. Again, it's kind of a litany actually of Lambda's work as I think about it. But we ranked all 50 states on this data, and we're going to be relaunching and refreshing the index on June 1 as part of our Proudly Resilient Pride, 30 Days of Pride, which we just did a press release on this morning. Out Leadership is convening 30 different days of events, including research launches, our climate index relaunch, as well as conversations like this every single day of Pride. And so you'll be seeing more about that in the news coming up. We're very, very proud of that. But I want to emphasize that because the idea of data and being able to rank these states was something we felt was very important, because then we could advocate to business leaders in the states, and we've created CEO business briefs to do that. So in Georgia, there is a CEO brief for business leaders like Katrina in Georgia, so that they can say to the companies that they work with and the government leaders that represent them, this is bad for business and here's why. And so, I'd love to think a little bit about the question, Jenny, for you and for Sharon and Katrina. Let's go through the outcomes. What do they mean? Right now in 27 states, I believe, we can be fired for being gay, and 33 for being trans. Obviously, that'll massively impact that. But one of the things that I think both of you did beautifully at the Lambda board meeting last weekend was talk about the multiple different outcomes and then how that impacts the Equality Act, and what do we still need the Equality Act after this?
So I can launch into this, Sharon, if you like, and you can fill in. We do sometimes a little tag team here on covering this.
Is there choreography, or is it just that? I mean,
it's just naturally moving on the same wavelength, I think. So I mean, of course, the court could rule favorably that there is current non-discrimination coverage in the sexual orientation cases and not in the gender identity case, or vice versa. In the gender identity case, as I mentioned, the court might say, well, there is protection through this longstanding sex stereotyping line of cases, and we're not going to answer about gender identity. Or maybe, gosh, we don't know what to make of this gender identity question. It kind of confuses us. I mean, who knows what they might say. On the sexual orientation side, the logic is very straightforward, and the decisions that have been won below, the couple of cases that we won on that from the circuit courts, I think uses very straightforward logic, saying, by the way, in the past, courts said things like, well, we didn't know what Congress couldn't have meant this back in 1964. And Justice Scalia said, like, well, who knows what was in their minds? That was a whole bunch of people thinking a whole bunch of things. That's not how we just read the law, we read the words, we apply the words. And that would be a pretty straightforward way to go. It would be shocking for them to say, oh, gosh, it would cause social upheaval, especially because of the incredibly impressive, huge, powerful array of friend of the court support. And in particular from business leaders saying, we do this already. It's good for business. We want the law to be clear. Clarity is helpful for those of us running businesses, because then we can tell everybody who works for us, yes, the standard of conduct is important and we're following the law. And so let's have an orderly place where people can succeed based on doing a good job. I think it would be quite a peculiar stretch for the court to say there will be massive social upheaval in the face of that, showing that is not how social leaders see things. We saw in the affirmative action cases some years ago that it was very important that major universities and military leaders said, please don't tie our hands as we're trying to achieve better racial diversity and racial justice in our large workplaces. That the court heard that. Now, it was a somewhat different court then, but those ideas are still, I think, very powerful. But to the question of the Equality Act, which is a bill in Congress, I hope everyone's familiar with it. I hope people are ardently excited about it. The House passed it with a wonderfully strong vote back in May, so it's in the Senate now, ready for some happy attention from Mitch McConnell whenever he decides to take it up. And Sharon's going to talk in a minute about what he's spending his time doing instead of embracing the Equality Act. We need that law. We need that bill to become law, regardless of what the Supreme Court does. And in my mind, there are really four key reasons for that. One is that we have these great sex discrimination arguments with respect to employment, housing, healthcare, education, and access to credit. But there's no protection, believe it or not, there's no protection in the federal public accommodations non-discrimination law against sex discrimination. I think there was a concern, perhaps, that too many ladies would go into men's clubs or something like that back in 1964, or an idea that, women and men are just so different that would be really problematic. Oh, it would cause great social upheaval or something like that. So that's not been in federal law for the past more than 50 years. It should be. And the Equality Act would add that sex discrimination protection, with sex discrimination defined for all of these federal civil rights laws in the way that we have been articulating it, as covering sexual orientation discrimination, gender identity discrimination, and also pregnancy discrimination, and medical conditions related to pregnancy, as all different forms of sex discrimination, like sexual harassment. It's all sex discrimination, they're just different varieties. And the Equality Act would write that into federal law. And also with respect to federal use of federal funding, that there's no protection against sex discrimination in the current law, and that should change. So those are two quite important areas. The other thing is there's a very important expansion of what the federal public accommodations law covers. Because when it was originally passed in 1964, it was a new idea, a very important idea. It focused on things like hotels, restaurants, and transportation, things that were similar to the decades-old, generations-old laws about common carriage and traveling, that people should not be turned away because there's no room at the inn for your type of people. But now we have a much broader understanding of what a public accommodation is, like retail stores, for example, and a broader sense of transportation and online businesses, the things that we particularly appreciate these days of sheltering in place. So that's an important expansion of federal law, and not just with respect to sex and sexual orientation, gender identity, discrimination, but with respect to race, color, national origin, and religion. It's important for our society as a whole to update that law. And the last point is there's clarity that religious beliefs are not a reason and not a legal excuse. Maybe a personal belief, it's protected, but it's not a legal free pass to violate civil rights laws. And that is a pretty critical idea, since that conversation, again, about what does religious liberty mean? Does it give you the right to turn people away from your business or fire people or refuse medical care, for example? And the answer for a long time has been no. The Supreme Court said that, other courts have said that, and that answer needs to remain the answer when it comes to LGBTQ people.
So let's take that last piece though. So like the Masterpiece case, et cetera, and these opportunities that people have taken to say, just because I am open to the public, I don't really have to be open to the public. How would that play out if the Equality Act passed?
Yeah, well, I think it would make clear that things covered by the public accommodations law, which means businesses, can't discriminate. And it would, in a sense, finish the job that Justice Kennedy did halfway in Masterpiece. In Masterpiece Cake Shop, he cited the barbecue restaurant case that had to do with religious ideas that racial segregation is ordained by God.
Piggy Park, wasn't that? Was a South Carolina case.
That was Piggy Park. That was barbecue restaurants. Barbecue restaurants in the South. I mean, what could be more when we talk about culture? So the Supreme Court said that religion argument was patently frivolous. That if you're serving barbecue, you got to serve barbecue to everyone. I'm not going to say everyone has a constitutional right to barbecue, but that's maybe it's a statutory right to barbecue. And religion does not give a free pass. So he cited that decision in Masterpiece, which basically says that's the rule that applies the same way to sexual orientation discrimination, but he didn't actually give it to us as a holding. He kind of came up with a contrived way, in our view, to dodge and decide the case on other grounds. And that left the door open. It was actually taken by some folks, including those who are determined to block the LGBT civil rights movement, to continue to bring cases to try to get a different answer, to try to get sexual orientation and gender identity discrimination treated differently than what our country has done for decades now. And we're seeing that in the series of cakes and flowers and other cases that Lambda Legal and our friends in other advocacy organizations will continue to have to fight those cases, making these arguments again and again. And I will say, this is where all the voices, business leaders, moms with 4 kids in Georgia, it is requiring that we maintain the national conversation to confirm that civil rights laws need to mean the same thing with respect to all of this kind of discrimination, and that religious beliefs are 100% absolutely protected. That's beliefs, but conduct is not always protected if it's going to hurt other people. And that's true if you're operating a business, if you're operating a child welfare agency where you're acting for the state with state money, with respect to other people's kids. I mean, there's a host of contexts, and there was a question in the chat about this, about why are we still having to fight about adoption when that issue was litigated successfully years ago in Florida, for example, very important case. But the answer is that these are religious entities seeking public money to act for the state. And that legal issue is still hotly in dispute. It shouldn't be, but it is. And so that's the playing field, if you will, where we're needing to engage the courts more deeply, legislatures more deeply, and the public to understand that religious liberty does not mean the ability to take taxpayer money to do the public's work for the public, but in a discriminatory way. That's not okay.
So I want to key on two things, and I want to get a perspective from Katrina and then go to Sharon. How do we synthesize that into something that's bite-sized that everybody can understand? I mean, you said something that I think was brilliant. You always say lots of brilliant things, but I really keyed in on religious belief versus religious conduct, right? Just that thing, because the argument from the right is you're infringing my beliefs, my beliefs, my beliefs. They never talk about the actions that belie those beliefs and that are driving those beliefs, and that's what the issue is. And I think that's such a core, central, easy thing. It's so obvious. And so I'm interested, one, how we communicate that better. And I'm actually curious, Katrina, from a business perspective and with your clients and with Baker and I think from a leadership perspective, I know with our firms, and obviously Baker is one, how do you think we can, and as an ally as well, how can we start to communicate this in a different, more clear way?
If I may, I mean, one of the things that has been extremely outrageous is going through this COVID crisis, that I have read articles about evangelical organizations asking the medical professionals to require them to subscribe to their statement of faith in treating patients that are suffering from COVID. Yeah. And, I cannot believe that somebody would go into that situation and decide that, the LGBTQ patient doesn't deserve that care and send them out into the street. But that is happening. And I think the more education we can do of society about like the real impact on people's lives, maybe we can move the needle a little bit. But from a business perspective, most businesses that in the Fortune 500 have policies against discrimination in the workplace, but that's just a policy. And that doesn't have the effect of a uniform law. And our employees travel and they go other places, they meet with clients. They don't need to be subjected to sporadic policies of other companies. They don't need to go into a situation that actually potentially harms them. And also our employees are married to people maybe that work in organizations that don't have any policy at all. And, these people, especially now going through the COVID crisis, get their health care from where they're employed. And if they're, the statistics are astounding about the number of people that experience discrimination in the workplace even now. People that don't, aren't promoted, they lose their job, or they're never hired. I mean, this has an impact on people's health, and that invariably impacts their children and their families and their ability to contribute to society. And we have to be more aggressive than saying our business has adopted a policy on diversity. That is not going to cut it. I mean, we have to get some more uniform protections, and we have to have the law behind us. And I don't think we can stop as allies until something is done.
And telling those personal stories, right? The more that it is talking about you as a mother of four and the impact that you're seeing. And even, you just mentioned the concept of minority stress, right? That health outcomes of minorities, not just LGBT, but African Americans, et cetera, go down because of the stress of discrimination.
And we live in the South. I keep bringing this up, but we're one of 4 states that don't have a hate crimes bill. And I don't know if you've all watched the news, but we need a hate crime bill in Georgia. And most of the cases, I will continue to say, of the 100+ cases we have on our docket at Lambda Legal every year, 70 are in the South.
Yep.
So something has to change.
Well, so we've got 5 minutes left, and Katrina, I want to underline your last point. Something does have to change, and with all the work that everyone's doing, hopefully it will. I'm the eternal optimist, so I'm counting on it changing. There were a couple questions in the chat that I think if we can quickly bang through, I think they would be very useful because I thought they were kind of interesting questions. So any discussion points on the SCOTUS orientation cases? There was more chat on Amy versus the trans piece versus the sexual orientation. Someone actually said the answer to my question around conduct versus belief is that the First Amendment protects the exercise of religion, which they take to mean conduct. So how do we think about those? So if we can quickly, maybe Sharon or Jenny, whichever one of you'd like to take that, and then I want to round out with just sort of where we go from here. So let's if we can quickly bang through that. Let's see if we can do it.
Yeah, absolutely. On the sexual orientation cases, our arguments are very similar. And there are some places where there's actual overlap between the sexual orientation and gender identity cases, because as for transgender people, LGBT people are running into stereotypes about what appropriate gender roles are for men and women and what kinds of relationships that we should have. So in that sense, the sex stereotyping argument is one that overlaps in both cases. There's also, again, the argument that I said in the beginning, the notion that Don Zarda can, get fired when he has a husband, but Donna Zarda is fine when she has a husband. Again, that's the only thing that's different between those employees is their sex. And the fact, and one case actually out of the Seventh Circuit that we won on behalf of Kim Hively, which was one of the first breakthrough cases in this area, you have, a judge saying it is impossible to take sex out of sexual orientation. I mean, sexual orientation is a concept that is based on relationships based on the sexes of the people involved. So the fact that it's a distinct concept doesn't mean that they're not inextricably intertwined. And then the last argument that is in play that's unique to the sexual orientation cases actually draws on a line of cases about interracial relationships and people who were penalized for being engaged in what were considered to be inappropriate interracial relationships. Now, in this case, the inappropriate relationship is the same sexness of it as opposed to the different raceness of it. But again, that is one of these very clear line of cases that any judge that sort of looked at it has had a very hard time explaining why it doesn't apply on all fours. So in the questions about whether or not the cases could come out differently, I think there's sort of a larger reason why it's likely that they will be decided in some way that can be, sort of viewed as a package. But there are distinct tracks for each one of those claims that could result in a ruling for why sexual orientation is covered that would not necessarily apply to gender identity. And then to David's point about this notion of the fact that there is the exercise of religion, I think as we're talking about with the Equality Act, the big elephant in the room is the fact that even if we write in all of the right statutory language, they're coming in with a constitutional gorilla to basically say we've got a First Amendment way to get ourselves out of whatever law that Congress passes. And that really ties into this notion of how is the First Amendment laid out in terms of what is viewed as a burden on religion. And it's one thing to say you cannot go to church, right? Or you must work and violate your Sabbath. It's another thing to say, I want to be able to go out and get a business license and sell a whole bunch of stuff and make profit for my company, but it's a burden if you ask me then to serve everybody, right? Now, unfortunately, we've got people who have been confirmed to the Supreme Court and many, many people who have been confirmed to lower courts, because this has been a pet project, who want to take a really, really aggressive view of what counts as a constitutionally impermissible burden on someone's religious exercise. And that's really where a lot of the fight is going to happen. And that's why, in addition to litigating these cases, Lambda has spent a significant amount of energy over these last 3 years calling out, the crisis that we are seeing with respect to the federal judiciary, because there are a number of people who are being pushed for lifetime appointments who are in their late 30s and early 40s, who could be on the bench for 40 or 50 more years, who have a very radically different view of what the Constitution means. And because that constitutional trump card, and I use that kind of tongue-in-cheek intentionally, has the potential to really override things that are passed in the federal legislature, but even in state and local legislatures, that is why we need to take what is happening to the courts as seriously as we take what is happening in our local communities and in Congress as well.
Well, Sharon, I think that is a perfect spot for us to wrap up on. I want to thank the three of you for several things. One, for being amazing leaders, for being visible, for being vocal. I want to thank Sharon and Jenny in particular, from a Lambda perspective, the number of hours that you guys toil in all kinds of places to protect the rights of millions of LGBT people. Oh, look, all while being a great mom is amazing. And I know that even in the darkest of times, when we have leaders like you guys and organizations like Lambda fighting for our rights, it makes me feel so much more secure about the future. And Katrina, thank you for being an amazing ally, and for the work of BakerHosteler, and for supporting Lambda with all of your efforts. I hope everybody has a fantastic weekend. I will just close on two quick notes. One, the Proudly Resilient effort that I mentioned, we will be hearing more about next week. And there was a question around slides and some feedback info. So I'll make sure that Lambda, I know, has a number of materials, as does Out Leadership, and we'll compile a little package and send it out to everybody with the recap and the replay of this podcast so that you can share it more widely. And let's all wave goodbye to Sharon's adorable daughter. Thank you for joining us. Have a great weekend, everybody.